How's it going, everybody, and welcome back to Lead Therapy. I hope everybody's doing well. If you haven't been living under a rock for the past couple of days, you should know by now, especially with all the videos that have been put out on YouTube, about the ATF's new proposal on pistol braces, using a very confusing 4-point system to find out whether your pistol brace is legal or not. And in the video I made a couple of days about it, I mentioned a couple of times that this system was made up for people to fail it. I personally don't know of anybody that would score below 4 points in that system. And now that the comments are open, everybody, I mean everybody, needs to go to the website and oppose this new rule. And I think it's fantastic that I found out this morning that the Texas Attorney General Ken Paxton sent a letter to the U.S. Department of Justice and the Bureau of Alcohol, Tobacco, and Firearms and Explosives, the ATF, opposing the recently proposed rule factoring criteria for firearms with attached stabilizing braces. On June 7th, ATF published a new notice of proposed rulemaking on its website. The rule seems aimed at making nearly all configurations of firearms equipped with stabilizing braces subject to the taxation and registration requirements of the National Firearms Act. I'm now going to put up on the screen so you can follow along with me the letter that the Texas Attorney General Ken Paxton sent to the DOJ and the ATF. As you can see, it's dated June 9th, 2021, and it's addressed to the Honorable Merrick Garland, Attorney General, and to the Honorable Marvin G. Richardson, Acting Director of the ATF. I strongly disagree with the recent notice of proposed rulemaking on factoring criteria for firearms with attached stabilizing braces, issued by the Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF. The proposed rulemaking would retroactively impact gun owners that lawfully purchase pistols with stabilizing braces under the ATF's previous standards and force a new federal registration regime on future users of the accessory. The stabilizing brace is used for a range of legitimate purposes. For many, the accessories help reduce recoil, prevent injury, and allows individuals to more safely and accurately operate a pistol. The accessory also allows disabled individuals to more easily and safely control heavy pistols without assistance. The stabilizing brace is also in wide use. According to the Congressional Research Service, there are between 10 and 40 million stabilizing braces and similar components already in civilian hands, and altering the classification of firearms equipped with stabilizing braces would likely affect millions of owners. The proposed rulemaking issued by the ATF purports to establish objective criteria for classifying these stabilizing braces. However, the standards are far from objective, but rather confusing and subjective. These ambiguous criteria could reclassify pistols with stabilizing braces into firearms subject to classification under the National Firearms Act, imposing upon owners a range of federal registration requirements and fees. And because the proposed rulemaking fails to notify millions of gun owners whether their firearm complies with federal law, it leaves law-abiding citizens guessing whether they are complying with the new standard or committing a federal crime. The new federal registration requirement would not only be time-consuming and cumbersome, but also places an additional and unnecessary expense on Americans exercising a basic constitutional right. As the notice of proposed rulemaking admits, the estimated cost of complying with the proposed rule would be in the hundreds of millions of dollars. Yet this new regulatory regime does nothing to deter crime and only traps law-abiding gun owners in expensive red tape. And the last part of his letter says, as the Supreme Court has made clear, the Second Amendment protects firearms in common use. District of Columbia versus Heller, the Second Amendment surely elevates above all other interests the right of all law-abiding responsible citizens to use arms in the defense of hearth and home. And this is the great part at the end. My office will consider all available options to stop this action and any effort to restrict Second Amendment rights. Sincerely, Ken Paxton, Attorney General of Texas. I think you all will agree with me when I say that Attorney General Paxton is a stand-up guy and fights for Texans' Second Amendment rights. And like I said earlier in the video, now it's time for everybody to fight for our Second Amendment rights. So as always, please leave your thoughts in the comment section down below. And don't forget to like, share, and subscribe and hit those post notifications. And I will see you in the next video.